rise. Court is now in session. The Honorable Judge Lauren Lake presiding.
Please be seated.
Good morning, Your Honor.
Good morning. Good day, everyone.
Good day.
This is the case of Menon versus Griffin.
Damages must connect like puzzle pieces. Injury, treatment, cost. The invoice for diagnostics and a new ergonomic chair adds up to around $2,000, but the judge is asking a stricter question. Are these expenses the approximate result of the massage, or just life catching up with a sore back the day before a wedding? Without expert notes tying findings to a specific incident, especially when plaintiff said, "Go deeper," medical receipts are necessary but not sufficient. And buying an ergonomic chair may look like mitigation, but if baseline pain predated the massage, causation phrase. Receipts need context, not just totals.
Mr. Menon, you are suing Ms. Griffin for $2,500 because you say you suffered injuries because of a massage she gave you.
Yes, Your Honor.
Explain to the court.
So my ex-fiance and I went to Miss Claudia here for a wedding present that she offered to us. When we went there, she did my ex-fiance perfectly fine. When she came to me, all of a sudden there's a whole lot of pain going on.
So you got a massage, you and your ex-fiance hired Ms. Griffin to do a massage?
No, she offered us a massage.
She offered it to you. It was a gift.
Yes.
For your engagement?
For our wedding, which was the next day.
Oh, for your wedding?
Yes.
That was the next day? And you said ex-fiance?
Yes.
Okay, so this is gonna be good, Sean.
I think so.
So you get a massage and you say for your ex-fiance it was fine.
Mm-hmm.
Then with you, there was a lot of pain.
Yes.
Okay, when you say pain, what does that mean? Because I know I don't like those deep tissue massages because they are painful on purpose. So what was the pain?
This time it felt like there was just a sharp pain that I've never experienced before.
So Ms. Griffin, you gave Mr. Menon a massage?
Yes, ma'am. I gave them a massage for their wedding present.
Was it your first time giving Mr. Menon a massage?
No, I've gave them both massages before.
Oh, so they were past clients of yours?
Yes, ma'am. And
But
also,
this massage was a gift because they were getting married the next day.
Yes, ma'am. And he complains that now that there was pain during the procedure, but I asked him several times during the procedure, is this okay? He kept telling me to go deeper, like.
This is a mini lecture in risk management. Judge Lake acknowledges that paperwork matters, even for friends. Still, she zeroes in on verbal screening. The therapist asked about soreness. The client confirmed soreness and requested more pressure. That sequence satisfies a practical consent threshold. Think of it this way. Standard of care is partly documentation, partly conduct. Here, conduct shows check-ins and client-driven intensity. If there is no contemporaneous stop, no immediate report of injury, and independent evidence of prior strain from lifting equipment, the negligence bridge just does not hold. The lesson for practitioners: keep forms. The lesson for clients: speak up in real time.
With this macho attitude, like, he said that he can take it, and so I'm going to get a client what he asked for.
And so hold on, Mr. Menon, so you, during the massage, you were telling Ms. Griffin that you wanted more pressure?
Yes, I go to the gym on a regular basis, and you have to really dig deep to get through the muscles.
But you just said I was hurting you the whole time, so why would you tell me to go deeper if I'm asking you, is this okay? And you're telling me that it's fine, but now you're telling me that there was pain the whole time.
Right. And you're telling me the same thing, and it doesn't make sense. Make it make sense.
He's a liar, Your Honor.
Yes, Your Honor. She wasn't going as deep as needed to relieve the pain that was there.
So you're thinking that was a pain that you had in your back or whatever, and that if she massaged deeper, that it would then take that knot out.
Which has happened before, yes.
Okay, so you are admitting in open court right now that you were telling her you wanted more pressure in this massage.
Yes, Your Honor.
All right, so you asked for more pressure, she gave it, so why are you suing her for $2,500? What happened?
Now, due to the fact that my wedding was the next day and she's clearly against us being happy together.
Why is that, Yousef? Why would I be against you guys?
Wait a minute, how did we skip to that?
Yeah. Why would I be
we done
against
gone
you guys
from
being together?
massage to she's not happy you're with your fiance?
She's had problems with us before.
I've never had a problem with you before, Yousef. Why would I even be here? Why would I give you a massage, offer you a
All right,
massage?
hold on. I don't have all day, so tell me what's really going on.
Case dismissed. Judgment for the defendant. The judge calls it straight. The injury claim does not outrun the admissions about deeper pressure and pre-existing soreness. Also, courtroom psychology matters. When the judge senses the real dispute is about a message being relayed to the ex-fiancé, not the massage, credibility collapses. Big takeaway: if you are pursuing injury damages, lock down contemporaneous complaints, seek immediate evaluation that ties findings to a specific mechanism, and avoid undermining your claim with unrelated, but reputation-shaping, events. For service professionals, even with friends, do intake, document updates, and confirm pressure levels as you go.
What's really going on is this: we're here out of spite. He's upset with me because he's cheated on Paula, and
Who's Paula? The fiance?
Yes,
Ex-fiance?
my friend and his ex-fiance.
Paul, stand up. You brought Paula as a witness.
Yes.
Miss Deb, so you are the ex-fiance.
I am.
And your massage went just fine.
My massage went fine. His did too. He's just mad.
So you remember his reaction after he got the massage?
Yes.
What was it?
He was fine when we walked out. I actually saw him hurt himself the week before. He was putting together a home gym in our garage. He tweaked his back and was complaining about it the whole time. When we got there, he kept telling her to go deeper. She did, and he was like, this don't faze me, because he want to be macho all the time, and he was fine. Afterwards, we had my bachelorette party, to which, when she disclosed to me that she knew he was cheating on me. So I called off the wedding. Now all of a sudden his back hurt and he want to bring somebody to court.
Exactly.
Coming up.
Were you having an affair with someone while you were engaged to your fiance?
I wouldn't call it an affair.
What would you call it?
And later.
Paul is following me around and still in his robe. He's kind of lingering as I'm doing my
Mr.
chores.
Francis
Yes.
is following you around the house
Yes, while I'm doing my chores.
in his robe.
We're back with the case of Yousef Menon and Claudia Griffin, who are fighting over a massage injury.
You say you saw him injure his back. Ms. Griffin, did you have them sign a waiver or, an acknowledgement of prior issues with their body?
As far as paperwork, no ma'am, because these are my friends. We have done these massages before. I do have a normal procedure for my other clients where they fill out a checklist.
Did you bring that checklist
Yes,
with
I
you?
did. Yes, I
May I
did.
see it, please?
My license is also in there. I've been doing this for 10 years. I've never had a
Thank you.
problem before, so I've
Your
never had a problem.
license is here.
Yes.
And then this is the paperwork you have clients fill out.
Yes.
On their first visit to you, did they fill this out?
The first time I've ever worked with them, I did have them fill out something.
Do you remember them having any injuries? Did you bring that paperwork?
No, ma'am, that was years ago. We've been friends since college.
When you came in for this massage, did you ask both of the parties verbally, do you have any areas you want me to avoid or no?
Well, he had already told me that he was feeling pain, and this is the reason why I offered them the massage, because he said that he was having some pain and he wanted to have a pain-free day, the day of his wedding.
I told you I was sore.
Right, but you did not disclose to me that you had an injury.
All right. What evidence do you have that Ms. Griffin injured you?
So I have my medical record from the day after. So instead of our wedding, I went to the hospital to have everything.
I'd like to see
have
that.
everything-
Sean,
to have
can we
something.
that evidence, please? So after the what?
After the massage.
I was going to say after the wedding, you didn't have no wedding because we didn't even get to that part yet because you got found out.
Right.
That part.
Talk about applying some pressure.
Right.
That part.
You applied some pressure, all right. Were you having an affair with someone while you were engaged to your fiance?
I wouldn't call it an affair.
What would you call it?
More like an entanglement of spirit.
An entanglement of what?
Spiritual, like she.
He's a clown.
An entanglement
He's a
of
clown.
spirit.
He's a liar, a cheater,
Sean,
and a
you've been
clown.
in an entanglement of spirit?
Not this week, not last
Not
week,
this-
not ever.
Not this week. Listen.
Do not blink. Our second case trades massage tables for a nanny retainer gone sideways. We are moving from negligence to contract-adjacent expectations and workplace boundaries in a private home. The $700 is not framed as a bonus. The family calls it a retainer to ensure continuity during their trip. The nanny later quits and says she felt uncomfortable with dad's behavior in a robe. Small talk veering into personal territory, robe slightly open. Now the court must weigh two threads: the text trail defining the money's purpose and the credibility of discomfort claims when there was no immediate complaint. Watch how the judge splits equity from contract.
You got caught. And so what is this paperwork? A medical invoice?
It's a medical invoice and also the cost of a chair that I had to purchase in order so I could perform my job. There was no way I was able to
So a medical invoice of $2,000, what it took for you to get x-rays and a readjustment, and then you had to do a scan, then you had to buy a chair, an ergonomic chair, because what, your back was killing you?
Yes, and I was unable to sit in the chair provided.
This is clear. Mr. Mena, listen. When you're gonna put together a whole piece of gym equipment, I can understand how your back could be sore or aching, right? When you go into a service, you should let your massage therapist know exactly what you've done and where you've gotten pain. Now, Ms. Griffin, I do have a problem with, even though they are friends, you need to understand why the paperwork you submitted to me is important. However, I do understand that if you have reoccurring clients, you know, even at the place where I get massages, I do not do the paperwork every single time, but I have paperwork on file, and it is in the contract that if things are updated, I need to make sure I'm updating, and they also ask me verbally.
Words matter. The text says, "We will be sending you $700 for the missing 2 weeks. That reads like a hold payment to keep availability, not a blank, thanks anyway, tip." Outside of law, retainer often gets misused. In law, retainers typically secure future work and are worked down by billable hours. Here, no legal retainer rules apply, but the everyday understanding still suggests, we pay, you stay. The nanny's analogy to lawyers does not carry weight without a shared definition. The judge will ask, did the family reasonably rely on her continued service after paying? And did her later discomfort excuse performance?
What has been testified to today is that you did ask him. And he did respond that he was feeling some pain because he was sore. Yes. You also testified that you asked for more pressure. So, in this court's opinion, you have not proved sufficiently that any injury or pain as a result of this massage was caused by the therapist, or was it caused because you already were sore or sustained some level of injury when you were putting together the equipment?
It wasn't a whole gym
Stop
equipment.
talking,
It was
Mr.
like,
Minute. Stop talking. Stop talking. Because what I see now is your issue is really not with her massage. Your issue is with her message that she relayed to your fiance.
Exactly.
And now, look, I only call it the way I see it in here. You in a massage full of pain talking about more pressure. That's what she's going to do. You can't then get up and say, well, now I'm injured, because you're not telling her that she's causing pain. Nothing. So this case is over because I can see clear through you. Mr. Manning, your case is dismissed.
This is the human factor. A robe at home is not automatically misconduct, but context is king. Prolonged presence while the nanny performs duties, personal questions about partying, and a robe slightly open creates an optics problem. 2 tracks matter legally. 1. Did the nanny communicate discomfort or seek correction? 2. Did the conduct rise to a level excusing her from continuing under the understanding tied to the $700? The judge reads this as gray area, not overt harassment on the record, but enough to validate that her discomfort was not invented after the fact. Silence protects no one. Speak up early and document.
Judgment for the defendant. Court is adjourned.
Thank you, Your Honor.
All rise.
Judge Lake has ruled in favor of the defendant. The plaintiff's case is dismissed.
And we're supposed to be friends.
No, you think this is
We're
funny,
supposed to be
Yousef?
friends.
Like,
No,
this
we've
is
been-
my business.
Oh, your business,
This is my
yes.
business.
Okay,
I
cute.
did you a favor.
You may now
That's the
exit
only reason why I
court.
agree
Baby,
with you
baby, can
that
we-
I wouldn't
Don't
go
baby
further.
me.
Coming up,
While he had his robe on and it was slightly open, that you felt uncomfortable, like he was potentially trying to hit on you.
Yes, and honestly, I wouldn't be surprised if that's why the other nannies didn't work out.
Here is the balancing act. The family wanted assurance. Pay now, keep continuity. The nanny accepted, worked a bit, then exited after a week, citing discomfort. With no explicit written terms calling the $700 non-refundable, the judge crafts an equitable middle. Partial refund reflects mixed responsibility. Household should be mindful about attire and boundaries. Nanny should not pocket all the assurance money if she knowingly took it to keep availability and then left. Small claims courts often temper hard lines with fairness. Practical takeaway: put expectations in writing, define what the payment secures, add a refund clause, and set household conduct norms in the agreement.
Paul and Melissa Francis claim their nanny took their money and a new job after they paid her to stick around. Jessica Cunningham says she couldn't stay once Mr. Francis behaved inappropriately.
This is the case of Francis versus Cunningham. Mr. and Mrs. Francis, you are suing Ms. Cunningham for $700 for breaking her nanny agreement. Is that correct?
Correct.
Yes, Your Honor.
Please explain to the court what happened.
Paul and I were going to go visit my parents in Philadelphia for 2 weeks. So as an incentive to keep her as our nanny till we got back, we offered her $700, which is basically her salary because we pay her $400 a week.
Did you accept this retainer, this amount, Ms. Cunningham?
Yes, I did.
Okay, so now what happened?
When we got back from vacation, she continued to work the rest of the week. And over the weekend, which she has off from us, she contacted me and let us know that she was no longer going to be nannying for us.
Oh, so when you got back, she quit.
Yes.
Your Honor, so I do have a text message here from them about these $700.
I'd like to see it.
Yes. So on here, it does not indicate that it was for an incentive for me to stay
Thank you,
with
Sean.
them permanently.
But the text message reads, let me see this. It says, hey, we know you want full-time work. Our family's going to go on vacation for 2 weeks and wanted to make sure you're taken care of. We'll be sending you $700 for the missing 2 weeks.
Yeah, so the $700, I accepted it in a way that, lawyers also have a retainer fee. So even if they give you their services or not.
$350 back. Half the retainer. That split signals two findings. First, the household created a setting that could reasonably unsettle a young worker: bathrobe, proximity, and personal chatter, so a complete clawback would ignore that harm risk. Second, the nanny took money plainly meant to preserve availability. Quitting shortly after the trip without prior boundary setting means keeping the full $700 would be unjust enrichment. This is classic rough justice: imperfect facts, shared responsibility, pragmatic outcome. For families hiring in-home help, I am in my home is not a defense to professional norms. For caregivers, raise concerns promptly. Do not let awkwardness become a contract problem.
They still get paid. And that's kind of what
that's not how it works. When you just happen to be talking to one. When you give a lawyer a retainer fee, they work off the billable hours for the retainer. You didn't do that.
Coming up,
He's still in his robe. He's kind of moving around. The robe's also shifting, so I'm looking away because obviously I don't want to see what's under there.
The robe is open.
we're back with a dispute between Paul and Melissa Francis and their former nanny, Jessica Cunningham, over a retainer.
Why do you quit when they get back?
So that week that I was working with them, it was a normal week. Monday through Wednesday was perfectly fine. On Thursday, however, during my morning routines, I put Thomas down for his nap. And as I was leaving the room, I saw Paul out in the hallway in the robe. And he said, oh, I thought I heard Thomas crying. And I told him, no, I put him down for his nap, he's okay. And so usually in the mornings I have a routine. I clean up the mess that we made that morning, I prep his snacks. And as I was doing all of my regular chores, Paul is following me around and still in his robe. He's kind of lingering as I'm doing my chores.
Mr. Francis?
Yes.
is following you around the house
Yes, while I'm doing my chores.
in his robe?
Yes.
Okay, saying and doing what?
He was asking me what my plans were for the weekend. He was asking if I was, kind of like a big party person. And, he's still in his robe. He's kind of moving around. The robe's also shifting, so I'm looking away because obviously I don't want to see what's under there.
The robe is open?
It's slightly open.
And he doesn't have on pajama bottoms or
No,
anything?
it's just a robe.
2 cases, 2 lessons. In the massage dispute, contemporaneous consent, pre-existing soreness, and motive collapse the injury claim. Documentation plus real-time objections could have changed everything. In the nanny case, fuzzy retainer language meets household boundary lapses. The court's compromise honors both the discomfort and the expectation behind the payment. Broader takeaway: in service relationships, bodywork or childcare, clear agreements and respectful, professional conduct prevent courtroom drama. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and do not forget to subscribe for more jaw-dropping courtroom breakdowns. Your support helps us bring sharper legal insights every week.
Okay, but once he realized that he was okay, why wouldn't he go back and put some pants on?
Yes, I was in my robe. I was not following her around. I'm in my home. I'm setting up, I'm getting a bagel, I'm setting up my workstation. I'm just doing my own routine.
And were you asking her if she liked to party and what her plans were?
I did ask her what her plans were for the weekend. I thought it was innocent small talk. I honestly didn't feel any uncomfortableness coming from her, and I didn't think I was overstepping my boundary or like being inappropriate in a robe.
Judge Lake's verdict when We the People returns. Promotional consideration provided by... You're watching We the People with Judge Lauren Lake.
So, Ms. Cunningham, are you testifying that while he had his robe on and it was slightly open, he was potentially trying to hit on you?
Yes, and honestly, I wouldn't be surprised if that's why the other nannies didn't work out.
Oh, all right, so the bottom line is you felt like he might be a little creepy, which I get. As a woman, I encourage you to own your power. If you feel uncomfortable somewhere, speak up, say something. Did she ever address this with you?
No.
She did not.
All right, so instead, you're a young girl. Instead of going and addressing it, you just said, you know what, I'm gonna go take this full-time job somewhere else. Where you're wrong is you took the $700 when you knew they were giving it to you so that you would not go work for another family. For this reason, it is the judgment of this court. I am actually not gonna award them this full $700 because I do feel like there was something there that Mr. Francis, in the future, you need to be more mindful when you have young women in your home, how you're dressed, how you behave.
We open with a clean dollar figure, $2,500 US, grounded in alleged injury and consequential costs. In small claims, plaintiffs win or lose on tight, practical questions: causation, notice, and credibility. A gifted massage the night before the wedding sounds generous, but gifts can still impose professional obligations if they are provided by a licensed practitioner. Here is the legal tension. Did the therapist breach a standard of care, or did the client assume the risk by directing more pressure, especially while already sore from assembling gym equipment? The judge is about to test that line. Keep your eye on 2 proof points: contemporaneous complaints during the massage and medical documentation tied to timing.
For that reason, I am going to order that you return to them half of the $700. Judgment for the plaintiff for $350. Court is adjourned.
This is the moment that matters. Informed, ongoing consent during a bodywork session. When a client repeatedly asks for deeper pressure, and the practitioner checks in, liability becomes harder to pin unless technique clearly departs from accepted standards. Courts often look for red flags. Did the therapist ignore explicit stop language? Were there signs of acute distress? Here, the record shows the client wanted more pressure, citing gym habits and tight muscles. That is classic assumption of risk territory. You cannot invite intensity, then later label that intensity negligence, especially if you did not object in real time. Notice also how the judge keeps narrowing the question to causation. Plot twist. Motive evidence. When Claudia alleges Yousef cheated on Paula, and Paula confirms, the case's emotional core shifts. Credibility is not just truth versus lie. It is whether the court believes your narrative is why you are really here. If a plaintiff's grievance stems from embarrassment or retaliation, say, a friend exposing infidelity, the money claim starts looking like a message. Judges pick up on that instantly. Also note, bringing Paula as a witness amplifies memory of events. She recalls the pre-existing back tweak and his tough guy, go deeper posture. That corroboration undercuts causation, anchoring the story in prior injury, not malpractice.